only on the good of DeFi for good and cover legal aspects of ESG and SRI for DeFi. Well, talking about ESG and SRR means talking about two new concepts, well, new or old concepts in fact, but new in terms of legal point of view. Well, ESG versus SRR, because they are quite different. Let me explain a little bit, and then after this definition, we can go deeper on the legal aspects and then explain how it works with DeFi for good. SRR was originally developed to allow investors to avoid companies they disliked for ethical and value-based reasons, and it's more in fact a kind of individual values, because the original form of SRR means about exclusion and native screen investing, and today we talk about impact investing, we talk about ethical investing, and if we talk about impact investing, which is very popular today in the world of investment funds, we talk about working with companies who try to solve social problems like pandemic and unemployment or recidivism, etc. So you see, it's more individual values. But if we compare to the ESG, ESG is a totally different concept, because we talk about environment, social, and governance, and it's an integration of these three concepts: environmental, social, and government risk into the traditional financial analysis. So ESG is more an economic value, which was also used by the legislator, European legislator especially, to be a legal criteria of sustainable finance. Because here we talk about sustainable finance, and ESG is a criteria European Union, but also third country used to be the legal criteria. And why we use criteria? It's because you probably know that ESG has been decided to be the criteria to avoid greenwashing and to harmonize and centralize all the concepts behind ESG. If we look at the new recent regulation of European Commission, you will see that called SFDR, non-sustainable finance disclosure regulation. Sustainable finance has been defined by the regulator as an economic activity that contributes to an environmental objective, and also like renewable energy, raw materials, waters and land, greenhouse gas emission, etc., but also that contributes to a social objective. In particular, an investment that contributes to tackling inequality, that foster social cohesion, social integration, labor relations, etc. And the last, the G, is the good governance practice. And in addition to this free acronym ESG, but what is important for the legislator is that such investment in E or S or G should, provided that such investment do not significantly harm the other objective. So if you invest in environment, you do not significantly harm the other objective, which are social and good governance. Everything should go together, everything should go up, should be harmonized until this free acronym ESG. And that's why the legislator focused on the ESG side and not on the SRR, because it should be defined to avoid greenwashing and to avoid such decentralization of the definition. So today, if we focus on ESG, we focus on dark green, Article 9 SFDR, or we focus on light green, Article 8 SFDR. But it's obviously the terms used by the legislator in European Union. And if we go further on the new legislation, we can see that the scope of the recent European Union ESG regulation try to give more transparency and try to inform first the end investors. Why? To avoid greenwashing, obviously, because the more transparent you are, the more you can inform your end investors. So the why is quite obvious. The why is the information of the end investor. But who is really important? Who needs to inform these end investors? Well, the recent European Union legislation focused on financial market participants. So financial market participants can be divided between the investment firms, portfolio management, all this kind of financial advisor, insurance intermediary, credit institution, investment firms, but it's also financial advisor and under LSFIN in Switzerland. So we have this and MiFID for EU law. So financial market participants should inform the end investors. But again, what they need to inform about financial product offered to the end investors. So virtually any financial products managed or offered by financial market participants are focused here by the legislation. More recently, the taxonomy, if we talk two, three words about taxonomy, focus only on the E of ESG. And that creates a little bit of mess, let's say, into the financial market, because the taxonomy only focuses on environmentally sustainable economic activities. So environmental objectives are focused by the taxonomy. So what about the S and G? Well, it's still a discussion. It's still discussed by European Union, and probably the social objective should be integrated in the new RTS to be issued end of June or beginning of July. And but the S and the G is still captured by the minimum safeguard to be aligned with OECD guidelines for multinational enterprise. So as you can see, the objective of the ESG regulation is to disclose and regulate at the entity level and at the product level. Entity level to offer more transparency via websites, via in the pre-contractual disclosure like PPM, offering memorandum, etc. Marketing communication should be aligned with the SFDR regulation. And at the product level, if you focus on the product itself, the product should be classified between light green and dark green. And again, all the disclosure should be disclosed within the website, within all the periodic reports, etc. So we have a passive information and we have an active information. Active information via all these media, which are the website, periodic, and PPM. But if we take a step back, what it means? It means that ESG is now regulated. You have a kind of centralization of all this data, and especially when European Union your Commission and ESMA will set up the platform on sustainable finance. The platform on sustainable finance will centralize all the data of the enterprise and the SME, and it is going to be a technical screening criteria and reporting instrument. So how can we deal with centralization, harmonization, and DeFi? This is the challenge for DeFi, and probably I will let Georgi have a look to this point. Thank you.
Thank you, Celine. I'll try to kind of speed up because mostly the ESG regulations through SFDR and taxonomy are applicable to centralized finance, and I think that was also addressed by our colleague earlier today. So basically the purpose here is to understand that as P2P is basically fundamentally working on a decentralized basis, that's the most important part, because there we have two basically an investee and an investor who were directly entering into contact in order to form a transaction. So this is basically outside the scope of the ESG regulation through the SFDR and the taxonomy. So here, typically, we will be not subject to any pre-contractual and permanent disclosure of information related to SRI or ESG. The most interesting part is really focusing on also intermediaries and certification. On the intermediary side, we see clearly that all the virtual asset service providers that operate basically on a centralized basis. So they offer their services in between an investee and investor here in terms of decentralized finance. We will be completely in the scope of the SFDR and the taxonomy, and there will be a burden, basically an obligation of transparency in order to establish what does the investor expect in terms of investment. Does he want environmental, social, or governance criteria, basically all three, and then on the other side to screen and do an enhanced due diligence on the investee and be able to basically represent and establish that he meets the ESG criteria of the investor. In terms of certification, it's very interesting because we see that Swiss is ambitious to provide these kind of services. In terms of certification of ESG, in some countries this is a regulated activity, and in other countries this is not. Like, for instance, subject to confirmation to Reto, in Switzerland, certification services are regulated and subject to an authorization. Rather, in Luxembourg, for instance, the certification authorities or companies are basically not subject to any kind of prior authorization in the field of ESG. We believe that most probably this in the near future is going to change a little bit, like the companies that provide actually financial data and advice. So we believe that also ESG analytics and certification is going to evolve in that way. But for the moment, it's not regulated in Luxembourg. There's some challenges, most probably beginning by the third one, which is the regulation of the certification, which is something which is uncertain and is going to change. The ongoing due diligence, basically, this is very interesting from a certification of the SRI and ESG standpoint, because basically the certifier would need to not only demonstrate that the loans are going to be used for an ESG objective, but also there is in terms of good governance, a continuing follow-up to be sure that basically the loans are effectively used in order to fulfill basically an ESG purpose. And the other one, which is very important, is speaking about impact investment. Most of the time, impact investment is basically focusing on the social criteria, but we also have requirements that if you are financing a social criteria, you must not significantly harm the environmental aspect of the ESG, and at the same time sustain good governance. So we see here that in the DeFi space there could be quite a lot of challenges. Now, considering that we have a very limited time, I'll just go through the Luxembourg regulatory framework with some certain legal sources. And it's interesting to see that basically the virtual asset service providers are covered by the AML legislation. This is since basically 2020, when the Luxembourg law transposed the AML5 directive. And we have several definitions. The core definitions are basically virtual currency, virtual asset service providers, safekeeping and administration, and custody wallet services are covered by the AML law in Luxembourg. And also the same law basically introduces the requirement to register with the Luxembourg Financial Supervisory Authority, which is the CSSF, and that has been effective since May the 30th, 2020, since the date where all virtual asset service providers must be registered with the local regulator. We have one additional and fundamental also aspect, which is regulatory for the DLT usage, is that the law on dematerialized securities in Luxembourg has been amended in January 2021 to basically transpose the possibility to use security issuance through a distributed electronic ledger or database. And that's very important because it's the fundamental piece of legislation that authorizes the use of DLT technology in the financial sector, especially for the security issuance. And also, it also gives a precision that central account keepers, who are basically the people that can use the electronic ledgers, can only be investment firms and credit institutions, which is, I believe, if I understood well what our French colleague said, is quite restrictive, because you really need to have a financial service intermediary license in order to be able to operate these kind of ledgers. And then a takeaway is, if you want to know more about the virtual, basically asset service providers, virtual assets and virtual currency, a very good lecture would be to have a look at the virtual assessment from the Ministry of Justice of Luxembourg, which basically gives a very exhaustive view on what the current state of regulation is and what are the full AML and